Hi, y'all. So on January 8th, I got an order from Judge Lee P. Rudofsky on my case against Portfolio Recovery Associates, LLC, a debt collector. And he's shown a bias the entire time. Like, this case was filed in 2021, early 2021. And he has shown so much bias. Now, he has an extrajudicial reason that you might have that bias, which is that before he became a judge appointed by Trump, he worked as counsel to Walmart. Walmart partners with Capital One, issuing credit cards, and Portfolio Recovery buys supposedly bad debts from Walmart. I don't know if they've bought Capital One debt, but I do know for a fact that they've bought GE debt that was partnered with Walmart. So I'm going to assume that they've also bought some Capital One debt. But, that gives Lee Rudofsky a reason to, kind of have too much of a leaning to be fair about this case. But he also showed that he had a bias by allowing Portfolio Recovery to put everything and anything they wanted under seal. And there is no way that this should have happened. Judge Rudofsky has fought on cases where there was an opposition to similar, not even as extreme, protective orders. And there the opposition was that you need to have a particularized reason to put something under seal. And even if something that's in discovery goes under seal, that doesn't mean that it necessarily will be under seal if it's used, like it was in this case, to make a decision based on the supposed facts. And the judge didn't let this case go to a jury. He decided, it's called summary judgment, he decided on his own that no reasonable juror could have agreed with me that there was no debt owed, and he got like, he said that saying even if there was a debt meant that there was a debt, which, okay, I don't know if that's some kind of lawyerese, but you all know what I mean when I say even if there was a debt, then that still didn't give the debt collector a right to call me continuously. I asked them not to call me. Even if the debt collector wasn't able to verify that I was the Laura Lynn they were looking for, that's even more of a reason that they should stop calling when whoever it is that's answering this phone over and over again says, stop calling this phone. And they say, but before we stop calling the phone, you need to verify that you are the person we're calling for. No? I mean, Judge Rudofsky agreed with them, but no, they need to stop calling any telephone number that any owner of that telephone number or any owner of that phone asks them to stop calling. So anyways, he had a total bias, wouldn't recuse himself. I go to the appellate court, the Eighth Circuit. I give a full length, like every character I was allowed to use, brief and reply. And I told all the reasons why the judge's orders were not correct. And the Eighth Circuit, in one paragraph, said, "We agree with everything that the judge said." They didn't give reasons why they disagreed with me. They just said, "We agree with the judge, we disagree with Laura, and so we affirm." So then I went to the Supreme Court, and the Supreme Court doesn't have to hear the case. The appellate court was supposed to hear the case. They were supposed to do more than they did. But I went to the Supreme Court and I asked them to hear the case or to review the case, and they eventually denied me. But before they denied me, Judge P. Rudofsky comes out with this order. He says, "Defendant has filed a motion to enforce the protective order issued in this case. That motion seeks monetary sanctions against plaintiff, including but not limited to attorney's fees related to the motion. But the motion also requests that the court order, at least temporarily, the complete takedown of a website, blog, run by plaintiff." Timeout. That's www.court-corruption.com. That's my blog. Okay, back to his writing. On this point, plaintiff's response argues that such a measure is overbroad and would conflict with her and her audience's First Amendment rights. In order to properly evaluate this portion of the dispute, i.e. to determine whether the requested takedown would be constitutional and justifiable, it was necessary for me to understand the full nature and content of plaintiff's website blog. In undertaking this endeavor, I came across a very significant number of unflattering and borderline offensive pieces the plaintiff has written about me. The quantity and quality of these pieces are far more numerous and far more serious than the minimal and fairly milquetoast pieces that the parties had brought to my attention previously. Well, really, it was Portfolio Recovery that brought them to his attention. But let's get to the real meat of this. First, he doesn't say how he undertook the endeavor. So he didn't give any order asking the parties to give him blog posts that would be determinative of if it might be constitutional to make a blogger take down her entire blog because of these supposedly unconstitutional writings, unprotected apparently by the First Amendment. Even if he just wanted to know if it was just so insulting, it's unflattering and offensive. Okay, so if you want to know if it was unflattering and offensive, that seems to be setting himself up for a reason to recuse. But that's what happened here. The judge, because he had a bias, ignored the canons of ethics that say a judge is not supposed to make an ex parte investigation into the case And he went ahead and made that ex parte investigation. Doesn't say how he made it, because it could be that he asked Portfolio Recovery to analyze the blog for him. It could be that he had his wife go on there, or maybe he just went himself. I did notice around that time that there was quite a bit of activity on my blog compared to usual. So there's a chance that he just sat there in his underwear at his house and looked at the blog posts. But whatever, he wasn't allowed to do that. Nobody has said anything about this that I'm aware of to the Judicial Ethics Committee. Something will be said eventually, I'm sure. But those complaints are confidential, so I have to look into what that means. If the person making the complaint, like if I decide to make a complaint against the judge, am I obligated to keep that confidential? That doesn't seem like, that seems like a violation of the First Amendment. So, I'll keep you up to date. Hey, if you have thoughts about this and you think that the people deserve to see what was in those documents that are kept confidential by Portfolio Recovery Associates and Judge Rudofsky and the Eighth Circuit, and tacit approval by the Supreme Court, just comment below and give me the thumbs up. Thank you.